In the previous lesson, we explored the concept of land charges as a way of protecting legal and equitable interests in unregistered title, and in doing so, essentially talk about the ways in which we can skirt around the doctrine of notice through the use of the Land Charges Act. This lesson is going to be relatively brief in terms of its descriptions, because what we're going to do is just talk about the kind of interests which are protected under the Land Charges Act, and we'll talk about the different classes of interest that exist. We noted in the previous lesson that the majority of these are equitable interests, but there are a couple of legal ones as well. Again, we'll get to that in a second. So we'll talk about, again, both legal and equitable interests, which are binding onto purchasers. We're not going to go into so much detail relating to what each of these interests actually mean, because some of them are going to be interests that we're going to explore in future lessons time anyway, as a separate series on chapters relating to things like easements and covenants, etc., etc., etc. So the aim here is to just be quite broad and descriptive in our overview of the kind of interest that exists on the Land Charges Register. So let's begin with legal interests, okay? Because there is only a limited number of them, we can essentially skip through legal interests very, very quickly. Given that there are only a few, we can just essentially examine them very briefly. If an interest in land is legal, then this automatically binds a purchaser normally of any owner of any estate, essentially. And so the legal interests which exist under the Land Charges Act would be void and inapplicable if they are not registered. So this is quite interesting, because it's quite strange to have something that is void and inapplicable because it isn't registered under the Land Charges Act, but yet is a legal interest, and so should automatically bind any owner of estate. So on the one hand, legal interest will automatically bind any owner of an estate, but on the other hand, if they are specifically legal interests which are cited by the Land Charges Act, then they have to be registered by the Land Charges Act in order for them to be binding onto the purchaser of an estate. Otherwise, they would be void and inapplicable. But the legal interest in question includes something known as a puny mortgage, which is a type of mortgage whereby the lender, the mortgagee, will not have the possession of the title deeds. And so, unlike the usual process where you have a lender that will often take possession of the deed to the property, for which they are going to be the mortgagee, the lender of the lender for the purchaser of the estate, a puny mortgage has a situation where you do not have possession of the title deeds. This is a legal interest which is registrable under the Land Charges Act. The second is the charge for inheritance tax, and a charge for inheritance tax is essentially where there may be a charge for inheritance tax on a particular piece of property. This charge will act as a legal interest in that particular piece of property. Just like with the idea of a puny mortgage, when this is in relation to unregistered title, it will be registrable by His Majesty's Revenue and Customs under the Land Charges Act. So it is the tax itself that is representative of a legal interest in a particular piece of property, where there is a charge that can exist over that particular property by way of inheritance tax. So that's the legal interest. Let's get into the equitable interest. There's a big list of equitable interests which can find itself as registrable under the system of the Land Charges Act. Now, how it is divided is into classes, and you have Class A all the way to Class F. And within each of these classes, there are a variety of different interests, okay? Now, a lot of the textbooks tend to just sort of overview some of the most important of which, but I'm going to just go through the list itself in its entirety. Now, what I should note is that the equitable interests, as cited in this, the classes A to F, include every interest which exists in the Land Charges Act. Okay, I just wanted to speak about legal interests separately because they are so limited in their abilities in terms of land charges. But when we go through this class list of from A to F, you will also see the inheritance tax provision. You'll also see the idea of a puny mortgage, and I've put in brackets where those are legal. So the ones that are in brackets, which are considered to be legal, I've stated in this on this slide. The rest are equitable. That's essentially what we've got. Now, where you can find this in more detail is Appendix D of the Government Land Charges Applications document list, and it lists the interest as follows. So, Class A will include a land charge imposed by statute pursuant to an application. So, this could be done, for example, under the Drainage Act of 1976. Class B include land charges imposed automatically by statute. This could include, for example, the Legal Aid Act of 1974. Class C is divided into multiple subsections. C1 is the puny mortgage, which is what we've talked about already, the legal interest. C2 is the limited owner's charge. C3 is a general equitable charge. C4 is an estate contract, probably one of the most important ones in this list. We then move to Class D of interest, which could be charged under the Land Charges Act. D1 is inland revenue charge. This can include a charge for inheritance tax, and as a result of which is one of those legal interests that we've spoken about, so an inland revenue charge. And you also have Class 2, which is a restrictive covenant, Class 3, which is an equitable easement, and then Classes E relates to the idea of an annuity. And then Class F talks about the protection of a spouse's or civil partner's right under the Matrimonial Clauses Act. So these are the all the interests that exist that could be registered by the Land Charges Act. Notice here that classes C1 and D1 are both legal. The rest are all equitable. Now, I've also made it clear that we are going to talk about some of these interests anyway as their own separate series of lessons. So we're going to do a whole chapter on restrictive covenants and equitable easements, for example. So don't feel like you don't know enough about all of these interests at the moment. Other interests in this list are not particularly relevant. So, for example, a limited owner's charge or a land charge imposed by statute or an annuity aren't necessarily that important. And the things that are important are the ideas of the puny mortgage, things like inland revenue charges, restrictive covenants, and equitable easements.